warm welcome to Bharata First. You're watching Big Picture with me, Frank Rausum Pereira. And since you're here, I would like to thank you for your continued support. For those of you who haven't already subscribed, please like the video, subscribe, hit the bell icon, and then all notifications. Do follow our social media handles for all the latest updates, and you can also subscribe to our newsletter to get some incisive content. The Bharata First team runs a daily Big Picture quiz. Please do participate by going through the description in Big Picture videos. Here are the UPI IDs for those of you who would like to come forward and make a contribution. A small contribution that you make will be a giant leap for us to keep bringing you this content. So do continue to show your love and support because I need it now more so than ever. All the information along with some must-see recommendations are in the description of this video. So please go through it. And now, moving on to the discussion. The Supreme Court last week cancelled the sedition case against journalist Vinod Dua and said a 1962 order protects every journalist from such charges. Vinod Dua was charged with sedition in Himachal Pradesh over his criticism of the central government's handling of COVID-19 based on a complaint by a BJP leader. He was accused in an FIR of spreading fake news, causing public nuisance, printing defamatory materials, and making statements amounting to public mischief. The journalist went to the Supreme Court against the FIR and sought exemplary damages for harassment. While cancelling the case, the Supreme Court rejected Dua's request that no FIR be registered against any journalist with 10 years' experience unless cleared by a panel headed by a High Court judge. In this edition of Big Picture, we will analyze the sedition law and its utility. Joining me on the program today are Kapil Sankla, Advocate of the Supreme Court, P.K. Malhotra, former Law Secretary, Government of India, and K.V. Prasad, Senior Journalist. Thank you to all my guests for joining me on this edition of Big Picture. K.V. Prasad, let me start the program with you first. Let's try and understand and analyze everything that has been happening with regards to the sedition law. Right now, of course, we saw it was in the news when the Supreme Court gave its order with regards to the case that was filed against Vinod Dua. Your thoughts on the sedition law and the media in particular?
Well, Frank, all of us have been following what's come up in the newspapers and media about this whole episode of sedition. We all know that this is a colonial law which we have been living with. History tells us that subsequent the Constituent Assembly's decision, well, 124 exists only in the law books, in the statute books in different form and format. And subsequently, there have been efforts to remove it from the books. The last two efforts were in 2011 and 2015-16 when private member bill were moved in Parliament, discussions were held, and subsequently withdrawn because the government of the day, irrespective of which party was in power, came up with its own formulation, some suggesting reform, some suggesting whatnot. The Law Commission comes with report, and lo and behold, but 70 years down the line, the debate continues. Here, I would like to make a small section, even though I belong to a media fraternity. I think the Indian Constitution is very clear that every citizen has the same right as you and I, as a irrespective of the professions that we are in. So the press by itself has no special protection under the Indian Constitution, unlike the American, where the First Amendment makes it very clear that the US Congress cannot pass a law curtailing the freedom of the press. So that having been said, so I would like to bring that up very clear that while the Supreme Court in its judgment does talk about the Kedarnath Singh case versus the state of Bihar and media reference in particular, I think that application will apply to every individual citizen. And if I were to take you quickly back to the Constituent Assembly debates where Dr. Ambedkar does make it a special mention as to why press is not entitled to a special provision. So I think that having been said, that those are the broad thoughts I would be at this point of time.
Absolutely. Some very valid and important points that have been raised. Let me take them forward. Mr. Malhotra, let me bring you in and talk about these aspects. You know, the Supreme Court has mentioned about the media and maybe giving it some kind of special protection. Does the media need special protection, especially considering that it is the fourth estate, fourth pillar of democracy, and so on and so forth? Or should the media be considered just as anybody else? And how do you relate this to the sedition law?
So the Supreme Court has always said that right available to the press, no doubt, are enshrined in Article 19(1)(a) with regard to free speech and expression, and subject to reasonable restriction that can be imposed under Article 19(2). But at the same time, Supreme Court has said that press is the strongest pillar of the democracy, because the press people only convey to the people what should happen, what should not happen. But only thing is, so if coming back to this sedition law, which has been a subject matter of debate for quite some time, and Mr. Prasad also mentioned that it's a colonial law, the fact remains it has not outlived its utility till date. The Supreme Court in very clear term has interpreted where the sedition law can be invoked. Unfortunately, what is happening, the governments of the law enforcing agency, in their zeal and enthusiasm to enforce this law, they go beyond what the law says and how the Supreme Court has interpreted it, and they don't try to differentiate between an anti-national activity and anti-government activity, and that creates all the problem. If the law is implemented by the law enforcing agency in accordance with the interpretation given to section 124A by the Supreme Court in various judgments, I don't see any difficulty with regard to this particular law. The Kedarnath Singh judgment, which is a constitution bench judgment given in 1962, has laid down the interpretation, what is the interpretation of section 124A, and it has very clearly said a citizen has a right to say or write whatever it likes about the government or its measures by way of criticism or comment, so long as, this is important, so long as he does not invite people to violence against the government established by law, or with the intention of creating a public disorder. I think this is what we have to understand. And if this interpretation is properly given effect by the law enforcing agency, I don't see why such a law cannot continue to exist on statute book. No party, when it has come to power, has decided to abolish it. They always wanted to retain it. But the same party, when it is in opposition, it talks about abolition of or deleting section 124A from the provision of IPC. Now, I again say you have to differentiate sedition law, whether an activity is anti-national or anti-government. It depends on that. Whether it is a Deshdroh or Rajdroh, it depends on that. In case it is a Deshdroh, you can always book a person under section 124A. But if it is only a Rajdroh, you are criticizing the policies of the government, you are criticizing statement made by the minister, law permits it, it falls within the free speech's expression, and probably this law, this right cannot be curtailed. And in the Vinod Dua case also, it is the law laid down by the Supreme Court in 1962 in Kedarnath Singh, which has been interpreted, rather quoted, and has been applied to the facts of this particular case while quashing the FIR against him. Now, if you look at the recent past, what has happened in Disha case in February, I think on February 23, granted bail by the court because law was not properly applied. Similarly, in the in Farooq Abdullah's case also, the PIL was dismissed on the similar kind of ground. In May, the Supreme Court stopped I think the Andhra Pradesh police from coercive action against the journalists who were promoting, who were giving certain news on the two channels, TV channels. And similarly, in the month of June also, FIR against Mr. Vinod Dua has been struck down by the Supreme Court. I think the misuse of this law is the concern of the common man and not the proper use of the law. I was looking at the data of the National Crime Report Bureau, and I find in 2014, 47 cases under this particular law was registered. In 2015, it was 30. In 2016, the number increased to 73. In 2017, the number was 51 and 228 persons were arrested. In 2018, the number has increased to 70, and in 2019, the number has increased to 93. So I think the concern today is the misuse of the law of sedition, and it is not that the law itself is in question. So I think with that, I leave it to the other panelists to give their views on this. And what we need is that the misuse of the law should be stopped. If you are using it properly, it needs to remain on statute book.
Absolutely. Absolutely. Now, let me take this particular aspect forward with you, Kapil Sankla, as well, because it's difficult to make this distinction, or a distinction has not been made about whether an activity is anti-national or anti-government. How do you, how do we sort that out, and how do we ensure that the law is not misused?
First of all, I'd like to compliment Mr. Malhotra for bringing a very fine distinction between Rajdroh and Deshdroh, anti-national and anti-government. And actually, this is the crux of the matter. When you are questioning the government as the seat, then and the intention to question is to incite violence, then it would be Deshdroh, it would be anti-national. But where you are questioning the government, full stop, or criticizing the government without any intention to call for violence, etc., 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 it can never be taken as Deshdroh. It would be Rajdroh. The other thing here is very interesting is that mere questioning or mere challenging the government can never be said to be anti-national or even anti-government for that matter. 124A, as the learned panelist very rightly said, 124A was incorporated subsequently, and the idea at that time was on the insistence of the prosecution branch. 124A very clearly says that whosoever by words either spoken or written, or by signs or by visible representation, or otherwise brings or attempts to bring into, and this is important, hatred or contempt, or excites or attempts to excite dissatisfaction towards the government established by law in India, shall be punished with imprisonment, etc., etc. So it talks about the government established by law, which is different from the government in power. And when these two merge is when sedition laws are misused. Now the Honorable Supreme Court in the Vinod Dua judgment very clearly stated that that the protection of Kedarnath will be applicable to every journalist, which in the judgment, the Honorable Supreme Court had said that allegedly seditious speech and expression may be punished only if the speech is an incitement to violence or public disorder. Now, this is the touchstone. In America, for example, the touchstone is that it has to be a conspiracy to do the same. There have to be two or more people who need to conspire together. Now, Kedarnath judgment actually gives 7 rules, which are the 7 tests. The first is that the expression the government established by law has to be distinguished from the persons for the time being engaged in the activity of the administration. The government established by law is the visible symbol of the state. The very existence of the state will be in jeopardy if the government established by law is subverted. That's one and the most important test. The second is any act within the meaning of section 124A which have the effect of subverting the government by bringing that government into contempt or hatred or creating dissatisfaction against it would be within the penal statute, because the feeling of disloyalty to the government established by law or enmity to it imports the idea of tendency to public disorder by use of actual violence. Or the third, comments, however strongly worded, expressing disapprobation of actions of the government without exciting those feelings which generate inclination to cause public disorder by acts of violence would not be penal. The Honorable Supreme Court clarified that a citizen has a right to say or write whatever he likes about the government or its measures by way of criticism or by way of comment, so long as he does not incite people to violence against the government established by law or with the intention of creating public disorder. The Honorable Supreme Court also stated that the provisions of the section read as a whole, along with the explanations, makes it reasonably clear that the section aims at rendering penal only such activities as would be intended or have a tendency to create disorder or disturbance of public peace by resorting to violence. It is only when the words written or spoken, etc., which have the pernicious tendency or intention to create public disorder or disturbance of law and order that the law steps in to prevent such activities in the interest of public order. And lastly, the Honorable Supreme Court in the judgment, in the Kedarnath judgment, had said, we propose to limit its operations only to such activities as come within the ambit of the observations of the Federal Court That is to say, activities involving incitement to violence or intention or tendency to create public disorder or cause disturbance or public peace. So these are the touchstones, the 7 touchstones that the Honorable Supreme Court laid down. And these are the touchstones that need to be followed, of course, with what Mr. Malhotra very rightly said as distinguishing between who is in power and what is the government of the day.
Absolutely. Absolutely. K. Prasad, coming back to you now, let me go back to a point that you were making earlier about how this is a colonial era law, over 150 years old, and it continues to exist even today. An aspirational India in 2021, do we need a law like this, or do we take a relook at the law? Because if you look at some of the other countries too, the Brits themselves have gotten rid of this law.
Well, that's true. The fact is today we are having a debate, and this debate keeps up periodically, keeps springing up periodically, and it's good in a democracy. Unless there is debate and discussion, and a very, very informed discussion at that, the sections of society do understand the pros and cons of a particular law which exists in the statute books. And as both my people on the panel have very elaborated, both the judgment of the Supreme Court, its various interpretations, and also the cases that Mr. Malhotra was referring to. One undeniable fact is sedition, the clause 124A has been resorted to by different authorities as and when it was required. Now, the test of requirement eventually has to go to a court of law for a court of law to adjudicate on the matter. Well, that is, but between the time when a police officer or an officer of a law enforcement authority at the local thana decides to file a case under this law, and till the time it moves through the criminal justice system to wherever it does, and it takes time in a country like ours because because of the sheer numbers that we have. There is an undeniable fact that it takes a toll on the person against whom such a law has been brought. So I think these are the issues that trigger the debate. These are the trigger points as to liberty expression. And also, let us look at there have been instances where a particular word or action or a symbol has been said, done, or by a person against whom the act, and it has had a cascading effect at some point of time. So the investigation officer or the police goes back into time zones and looks into it whether a particular word or action deed has led to what can be interpreted as against the government of the day, which is established by law. So these are subject matter of interpretations, which I'm sure all the courts and Mr. Kapil would himself look at it. I'm not a legal person in that sense of the term, but as an individual, these are issues that come up every time. And as I said, when Parliament 2011, the private members bill was moved, then government of the day said, no, we have to look at a comprehensive criminal justice system and want a comprehensive law which looks at the larger issues. Very rightly, as Mr. Malhotra said, they did not ask for that to be scrapped. 4 years, 5 years down the line, again, when Mr. Satish Tharoor moved the bill, but then Home Minister's office or whoever was responding at that time on behalf of the ministry came up with arguments which are, then we had the 2018 Law Commission report. So these are there, these are works that are available, but should we not move forward? That is the thing. And I think that comes forward only with the debate and discussion. Can we do away with the law? We have a different view on this panel, that's fair enough. But we need to arrive at some point of time. And just to conclude, I would like to say, I would like to use the interpretation in a cricketing analogy. Probably this is somewhat equivalent to a leg before wicket, with the umpire of the day who's standing at that end of the crease decides the ball would have hit the stumps. It's only now that you have a third umpire referrals which allows you to look into it. So this is just an analogy. I don't know if it really applies in the legalese terms.
It's a beautiful analogy, and for a cricket crazy country, I think you've just made it a little more easier now to just understand this whole issue in just one small analogy like that. Mr. Malhotra, this is a very valid point that Mr. Prasad is raising. And, how would you respond to this? Do you think that there's an easy, because of the contentious nature of this bill itself, should we just get rid of it? Because we seem to be embroiled each and every time with this entire issue. Then the courts have to step in at some point in time. When the government changes, the government feels like it has the power to do what it wants to do. So just so as to ensure that we don't get into this vicious cycle, do we take a relook at this law?
Well, Frank, I am of the, firm view that expression of view, which is different from the opinion of the government, cannot be termed as sedition. There cannot be two opinions of that. And also, the right of dissent is lifeline of democracy. That also cannot be denied. Now, sedition law itself is a brahmastra to maintain control and public order in the society. And this law, simply because it is in existence or it is a pre-independence era legislation or 1860 law or 1870 amendment law incorporated by Macaulay at that time because of the circumstances prevailing at that time, doesn't mean that because it's a colonial time law, therefore it has outlived its utility. The IPC itself is of a colonial time. It is of 1860. What we have to see is whether this law has been properly applied and implemented, because Supreme Court has interpreted it from time to time how it should be implemented, but unfortunately the law enforcing agencies, in their zeal and enthusiasm to score a mark, book people under the sedition law, which should not be done. Now, if there is no clarity in the law that is felt, then whatever interpretation has been given by the Supreme Court, whatever has been said in the private members' bill which were brought before the parliament, or whatever the Law Commission of India has said, taking into consideration all those facts, probably there is a need to bring more clarity in the law so that the law enforcing agency are not in a position to misuse it when they register a case. I think that is what is needed. Yes, you don't do away with the law, you bring modifications in the law to ensure that the authority or the power available to the law enforcing agencies is not misused, or it is applied in accordance with the law laid down by the Supreme Court. I think if that is done, the very objective of having this law on the statute book will be achieved, and we will be able to achieve that objective.
Absolutely. Kapil Sankla, let me bring you in here on this particular aspect as well, because it's an interesting aspect. Once someone is booked under this law, it's a non-bailable offense, and the person goes straight to jail, and then he has to wait to go through the entire legal system to actually get out of the woods, so to speak. So, is it fair for that person? I mean, from a barely from a legal aspect, I'm asking you this question.
You see, the law doesn't come into motion by merely a threat. It comes into motion by an act. Now, how the act is interpreted is the job of the police when they're investigating. Now, Lalita Kumari judgment of the Honorable Supreme Court is very clear that investigation can only take place after the FIR is registered. And CRPC is very clear that once the FIR is registered and there is a prima facie view, the police can arrest. So why only sedition laws? Why not overhaul the entire penal system then? Because then somebody would come and say that, X offense, Y offense, or Z offense, why should there be a separate law for sedition? That's one. Secondly, the Honorable Supreme Court recently another judgment also. This was pertaining to that two Telugu channels, news channels, where the Andhra police had accused these channels for airing statements of an MP who had rebelled against the Congress there and had registered a case of sedition against them. The Supreme Court very rightly said that now there is a need to define the scope and the limits of sedition. It did not ask that the sedition law should be actually given a go-by, should be removed. They said there is now time to actually see what are the limits of sedition law, and that is rightly so. And that also comes in any cases. You can talk about rape cases, you can talk about matrimonial cases, where we as Indians, when something happens, then we wake up and then we talk about overhauling that particular law. And every change, when you think about in the legal system, has come from some major case that took place, that was highlighted by the media. It came in public limelight. There were tweets about it, etc., etc. And then the executive, the legislature came to the rescue. So similarly, sedition laws require an overhaul. Yes, absolutely right. But are they to be completely removed? That would be quite a dangerous thing. And if you have time, I'll quickly say this, that I'm conscious of the fact that this is a very unpopular view, because I've done this in other forums as well. I believe that sedition laws are necessary evil till we as a nation are fully protected and secure, and for the lack of a better word, unfragmented. And your show is widely seen and appreciated. And on one of the previous programs, I made a statement that garnered a lot of attention and got a lot of calls from my brethren in the legal fraternity. It was pertaining to the issue of reservation. And I had said something which went contrary to the popular narrative. I said the reservation is here to stay and should stay till such time as we as a nation remain fragmented and fragmented on issues of caste, color, and creed. And I'm proud to say that most of people appreciated my candidness in making that statement. So let me make another statement here. I agree that sedition laws have been misused and shall be misused in its current form. I agree that sedition laws are very harsh. I agree that each charge under sedition is a serious infringement of the fundamental rights to speech and expression, and it has to be taken care that such action does not take place at the instance of whims and fancies of the government in power. At the same time, you will surely agree that some form of protection to the government, to the establishment is required. As we as a nation in its development, its thought process are still at its nascent stage. And we cannot really afford a lot of knocks to the established government. So the analogy is right about the leg before the wicket, etc., etc. But you also have to realize that the protective mechanism under the CRPC is already there. That the protection will always be there, that the police would have to make out a case. So what can be done today is to somehow create a more protective mechanism. What do? We can create a forum, an organization, a tribunal that can pre-decide a matter, whether it actually is sedition or not. Or we can probably empower National Human Rights Commission, NHRC, and say that every such case would require a sanction from NHRC or the organization. And the sanction law or the law of sanction is already pre-decided and pre-formulated, because in every Prevention of Corruption Act matter, CBI has to take a sanction. So the same way, probably we can create a sanction, a requirement of sanction, a buffer before the police misguidedly files a case or arrests a person. But should the law itself be given a go by? I surely don't believe that would be a wise decision.
Absolutely. It's time to get closing comments from all my panelists. I saw Mr. Malhotra putting up his hand. Go ahead. The floor is yours first, Mr. Malhotra. I'll take closing comments from the others after that.
Well, I see no reason to disagree with what Mr. Kapil Sankla has said. Rather, I fully agree and endorse the views which have been expressed by him. But only thing is, with regard to the protection to be given or the kind of safeguard to be built in, I again come back to the judgment given by the Supreme Court in Vinod Dua case, where two prayers were there. One was for quashing of the FIR, which the Supreme Court has done. The other prayer was for constituting a committee to look into all this kind of cases before they can go to the court of law. But the Supreme Court has not agreed to the constitution of such committee as they have done in case of doctors for medical negligence. That kind of committee, they are not agreed, saying that is for the legislature to take a call on this. To that extent, I personally feel probably what the Supreme Court has said, that is a step in the right direction. And now it is for the government to ensure that in the sedition law itself, that kind of safeguard which the prayer was made to the Supreme Court to bring, the legislature should look into it. And for invoking the sedition law, this kind of committee or kind of other mechanism, as Mr. Kapil Sankla is suggesting, that should be considered by the government and should be brought on record, so that the law is only used to protect the national interest, sovereignty and integrity of the country, and it is not misused to book people who are simply criticizing government of the day for the policy, or they don't agree with the policies of the government.
Absolutely. KV Prasad?
Well, I think the fact that we are talking of the need for safeguards in the light of the case itself shows that there is a considerable amount of movement in a direction. Yes, legislative is the place where lawmaking should happen. And that's where the debate and discussion, when the public debate begins, it goes into the parliament through members of parliament or legislatures. And just to bring a very quick point, Mr. Kapil Sankla had made, I think every country wakes up when there is a major incident. Just as in America, we all saw how that Minnesota episode of a Black Lives Matter resulted into a big debate in America that's still playing out. So I think it's pretty natural in a civilized society, and debates and discussions do place. A trigger happens just as the Nirbhaya case triggered a different kind of law. So I think this is very natural in a democratic society, that when an incident happens and we feel that we have been wrong, that people speak up. So that's That's my understanding of the way democratic parliament democracy works. But yes, safeguards, as I said, in the leg before wicket, we brought the cameras in, right? We are a referral system. So probably a safeguards would be built up as we go along.
Absolutely. And Kapil Sankla, close the show for us with your quick concluding remarks.
I agree with Mr. Prasad, but I think that is the misfortune of the world that we have knee-jerk reactions. A truly developed nation or a developed society would be where we do not have knee-jerk reactions and we can think beforehand as to what is going to happen to actually create a level playing field and a protective mechanism. In this digital world where every person has a smartphone, it's easy to be bombarded with information and misinformation. And it's not just dubious sites, not social networking platforms, but also in mainstream media that is guilty of putting its views over the news. And it's very easy to be misguided by wrong information or thoughts, which makes individuals have ill feelings towards the very nation where they've been born and brought up. So I think these protective mechanisms should be put in place so that we can actually truly punish the guilty and not just the herd that unfortunately followed the guilty because of the misinformation, etc. The sanctity of journalism rests on its impartiality, and it's imperative that we retain the same. But at the same time, we need to make sure that they're answerable to their own wrongs.
Yes, K. Prasad.
Frank,
Yeah,
very quickly, just to add, today every citizen is a journalist. He or she is empowered thanks to the social media. You don't need journalist specialist roles that we have done in the past. Today, everybody is an informed citizen. So I think the definition of journalism per se is changing. So I think that brings into focus what lawyer Mr. Sankla said. Yes, we are a responsible tribe, but then the tribe increases in a different form and form. I think every profession faces the same challenges as we go along in the society.
absolutely. All right. On that note, I'll call it a wrap on this edition of Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. Well, what's coming out of this discussion is that the sedition law has not outlived its utility. There is no doubt it has been misused, but repealing it completely will do us more harm. We should have adequate safeguards within the framework of the existing laws. The law itself is not in question, it's the misuse of it that is a problem. There must be a clear distinction between anti national and anti government. This will smoothen things out. Well, once again, thank you for your continued support. For those of you who haven't already subscribed, please like the video, subscribe, hit the bell icon, and then all notifications. Do follow our social media handles for all the latest updates, and you can also subscribe to our newsletter to get some incisive content. The Bharata First team runs a daily Big Picture quiz. Please do participate by going through the description in Big Picture videos. Here are the UPI IDs for those of you who would like to come forward and contribute. A small contribution that you make will be a giant leap for us to keep bringing you this content. So do continue to show your love and support. All this information, along with some must-see recommendations, are in the description of the video. Please go through it. That's it from me. See you again next time.